The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Hi, I'm Kevin O'Flaherty from O'Flaherty Law. I hope you find this Learn About Law video and podcast helpful. If you need some help, please feel free to give me a call at 630-324-6666. That's 630-324-6666. Thank you so much for watching and listening.
Hi, this is Andrew with Learn About Law, and in this video we explain the revocation of a trust based on consent or mistake in Illinois. A trust is both a document and a legal entity that can own property separate from its creator. A trust is created by an individual entity known as a grantor or settlor. Once the trust is drafted and executed by the grantor or third parties can transfer ownership of property to the trust. The trust is therefore a separate legal entity from the grantor that can own property, much like a corporation. Much like a will, a revocable living trust provides direction on how to distribute the grantor's assets when he or she passes, but unlike a will, trusts come with the added benefit of the assets avoiding probate. Revocable living trusts can be modified, adding new beneficiaries, changing what a beneficiary receives, including new property, etc., by the grantor at any time as long as he or she is still alive. The trust becomes irrevocable upon the death of the grantor and typically cannot be changed. An irrevocable trust cannot be modified or revoked by the grantor once it is executed. As such, adding an asset to an irrevocable trust will limit the grantor's rights to the assets. There are a couple of ways the courts can work around and revoke an otherwise irrevocable document. So revocation based on consent requires the settlor to consent to revocation and all beneficiaries to be accounted for, not incapacitated or underage, and consent to the revocation. If the settlor has already died, the trust cannot be revoked. If getting consent to revoke a trust is not possible, the settlor still has the option of revoking a trust based on the grounds that the power to revoke or some other language was omitted from the trust. It must be clear that the settlor was unaware of the language omission and or the omission was not due to any action by or suggestion by the settlor. Only the settlor can petition to revoke a trust based on a mistake. Evidence must be presented in order to make a case for revocation based on a mistake. There are no guidelines in Illinois for what type of evidence is required to revoke a trust based on mistake, other than that the evidence must be clear, convincing, and justify the revocation. Any evidence that finds the settlor created the trust to protect himself from creditors or estate taxes suggests the settlor had a strong understanding of the language and purpose of the trust, and that the settlor did not intend to preserve the power of revocation. Termination, revocation, or modifying a trust is not something a person can do alone. It's best to have a qualified trust attorney to help guide you through the process of creating, modifying, revoking, or terminating a trust. An error in the trust document or poor handling of any changes to a trust can lead to a slew of legal issues. For more information, speak to one of our attorneys at 630-324-6666. As always, thanks for tuning in.
Hi, this is Kevin O'Flaherty again from O'Flaherty Law. Just want to let you know we offer free consultations in many areas of law, and we have several geographic locations for your convenience. So if you need some help, please feel free to give us a call at 630-324-6666. That's 630-324-6666. And thank you again for watching and listening.